side?
Yes, my lord. Tomorrow, if it can be taken up.
Tomorrow will be difficult.
Friday, also no problem, my lord.
All right, we'll see tomorrow. Okay.
Which-
Oh, may I seek your lordship indulgence in making a mention with respect to part 2, item number 7, lordship.
Yes.
Lordship, I am appearing on behalf of the respondent. Lordship, if this matter may be taken up, may be fixed on 17 October, lordship.
Mr. Malhotra, you are appearing. Any objection?
I have no objection.
All right. Yes, your name?
Rosie Man Lomsangi, lordship.
As prayed for by MS Rosie Manlaum Sangi, Learned Counsel, appearing for respondent number, appearing for the
So respondent,
respondent
lordship.
with consent from the other side, list this matter on 17
October, lordship.
10 2024. Yes, Mr. Lalfa Goma.
Yes, Your Lordship. In respect of, sorry.
Permission, item number 1 and 2.
You wanted to make a mention, or it is your matter?
No. I'm item 1.
Yes.
I'm for the petitioner in this case, Your Lordship. We've come to somewhat of an impasse in this particular case, Your Lordship. The direction of this Honorable Court via its judgment and order dated 10/7/2017, passing WPC 123 of 2016 was that after taking into consideration all the necessary aspect, the properties of the lands of the petitioners should be acquired. And sorry, that was the second direction. The first direction was whether it should be acquired under the the old act or the 2016 Mizoram Act. So those were the two directions. So accordingly, if your lordship, if I can take your lordship's attention to the affidavit or show cause reply filed by respondent number 15. This is by the Chief Secretary, Dr. Renu Sharma.
Yes, 15.
Respondent number 15.
Yes.
The relevant page is at page 16, 16.
Yes.
So your lordship has it. It's a
Yes,
notification dated 26 May 2020.
Yes.
So, and right, and this is as can be seen from 1, 2,
Mr. Lalfa Goma, just 1 second.
I don't know.
See the not working properly. Put it in my direction. Yes, please.
Yes, your lordship. As can be seen from serial number 1, which is at the bottom, counting from the
Yes, the portions of the land.
yeah, the portions of the land of the petitioners in WPC number 122 and 123 of 2016. I am reading this just to emphasize the fact that this covers both item 1 and 2. So this one notification covers the two cases.
All right.
Now the impasse is here, lordship, lies right here at para number 3. The land acquisition award shall be made based on the market value of the petitioner's lands to be determined on 1/5/2013, the date the preliminary notification under Section 4 of the Land Acquisition Act 1894 was published.
Is the order of this court complied or not complied?
According to us, it's not complied. According to the government, it's complied. This is where the impasse is right now. I would like to take your lordship now. As
Mr. Lalfa Goma, then let me understand. First, show me the order. Where is the order?
right, we will come
We'll
to
come
that.
back to this affidavit again.
Sure.
But let me
Page-
first see the order of this court, which according to you has been violated.
Yes, your lordship. Page number 12 of my contempt petition,
This is the order dated 10/7/17,
my lord.
and the relevant direction is at page 20.
Correct. Para 11, page 20. May I
Please
read?
read that.
Yes, your lordship. Para 11. In the result, the writ petition is disposed of with a direction to the state respondents to take a decision as to whether the land acquisition proceedings should be initiated and completed in terms of the Land Acquisition Act 1894 or by the Mizoram Land Acquisition
One of the question is whether it has to be done under the
1894?
1894 or under the Mizoram Land Acquisition
Correct.
Act 16. This
Right.
is the first question.
That is the first question.
Yes.
The second is that the respondent number 2, that is the Commissioner and the Secretary to the Government of Mizoram, shall cause necessary process to ensure that the decision is taken by the state government within the stipulated time as directed. Upon
That is
the-
the 1 month, within a period of 1 month from the date of receipt of certified copy of this
Correct.
order. Correct?
Correct. my lord.
Yes.
Upon the decision being taken, the respondents shall proceed with the acquisition proceedings and complete the entire exercise within the
Within
period
5
of 5 months.
So
thereafter.
ultimately, after deciding whether which act to follow,
Right.
the acquisition has to be completed.
Within 5.
Correct.
Additional
This is-
timeline of 5 months.
This is the order.
Right.
It is also made clear.
Yes.
Similar situated and all that.
Landowners
so
who are
now,
affected.
First of all, what is the decision? Which act is
So the Mizoram Act has been invoked.
where do I get that?
Yes, right before at page 16 of the affidavit of the Chief Secretary, page 16,
Page 16.
16,
Yes.
at right above the above the serial number
Yes.
1. Now,
Now
therefore,
the governor
the governor of Mizoram, under the circumstances as mentioned here before
Of the
and
Mizoram.
invoking the provisions
So
of clause
this is the
A,
first part. This is complied.
complied.
Now, second part is the acquisition process.
Right.
So, what has been said? Please read now the
Right.
number 1 again.
The portion of the lands of the petitioners in the WPC number 122 and 123 of the 2016 already utilized or occupied for the right of way of the Damchera to Tuilut Kon portion of KD's at KT Road upgradation
This is
project.
all right.
Right.
So, if it is utilized, occupied for right of way, then it shall be demarcated and
Compensated.
Next, number
Second,
2.
the portion of such lands falling within the said ROW shall be indicated in the strip map. It should be
Now,
site
number
map, I
3,
think.
the land acquisition award shall be made based on market value. Now,
Right.
what is your problem? They have already
1 and 2 is fine. The problem arises in number 3. Number 3 says that the market value of the petitioner's lands to be determined as on 1/5/2013. 1/5/2013, whereas the date of this notification, this is a preliminary
Mr.
notification.
Alpha Kwama, you see, this is on the merit of this order, right?
That's why
Now, that cannot be decided in a contempt proceeding.
I am
As far
absolutely.
as this contempt
I am
court
in
is,
absolute agreement with your
contempt
lordship.
court is concerned,
I
I am
agree with your
only
lordship.
concerned whether the order of this court has been complied or not complied. I am not the executing court.
Absolutely.
correct?
Absolutely.
Now, you may
That-
may have some grievance that you may always come up before.
If
you
your
may
lordship
bring
can
it
kindly,
up
if your
before the
lordship can kindly
appropriate
bear with
forum.
me for 2 minutes, if your lordship can kindly
yes,
bear with
yes.
me for 2 minutes.
Yes, yes.
So my
Why
humble
2
prayer
minutes?
today.
I'll bear with you for as much minutes as you want, but
Right.
you have to confine yourself within the jurisdiction of the contempt petition.
That
Don't
is
travel
where
beyond that.
that is where everything
Yes.
boils down.
Yes.
So
Yes.
my humble prayer before this honorable court in
Yes.
respect of both item 1 and 2 is that since there appears to be some legal jargon, legal issue which needs further adjudication, my humble prayer is that either the contempt is allowed to be withdrawn or closed with the liberty given to the petitioners to challenge this notification.
You don't need that liberty.
Just for this.
You don't need that liberty. That is already there. You are, if you see, if the order of whatever they have, the orders that they have passed, if you have some grievance, remedies are available to you.
Nevertheless,
Do you-
if it is
do you
reflected
need a
as
liberty?
nevertheless, if it can be reflected as an abundant
And,
precaution, because now
Contempt courts are not executing courts. So where is the
I don't
question of
understood.
giving you liberty?
So
You see,
anyways-
as far as this court is concerned, it appears that the order of this court has been substantially complied. So I'm going to close this contempt. You will always have the liberty. If I will record your submission that as far as 3 you have some objection.
I have objections
I will
with this.
record that.
Yes, if that
I
is done at
record-
least, if that is at least recorded,
Yes,
then
Mr.
that should be fine.
Lalramenga?
Yes, my lord, I am representing respondents 3, 5 to 8, 12 and 13.
I'm closing the contempt.
Yes, my lord.
You want to
We
say
can
something
close.
more?
No, my lord. That's No, my lord, I have
I
nothing
can
to say.
bear with you also.
So let it be recorded at least that
Yes,
we will
that
be
I will record.
challenging this notification.
According to you, I will, your objection to clause number 3 is that it has based, what is the objection? Just say it again.
Yes, my objection is that as per this, the date for determining that market value is recorded as 1/5/2013. Now, as per section 26 of the Mizoram Land Acquisition Act, market value is to is to be determined on the date on which notification was issued.
Date on which
The notification has been issued
Alright.
under section 11.
Okay, fine.
So it should be 2020 according to me.
while I dictate that part, you may just assess the code. All
My
right?
lord. My pleasure.
Both item 1 and 2, same, right?
Same.
Heard Mr. Lalfakwama, learned counsel, appearing for the petitioner. Stop. Also heard Mr. B. Lalramenga, learned counsel, appearing for the respondent number 1, 3, 5, 8, 12, and 13. Correct?
Yes, my lord.
And anybody else?
I think no one is appearing for the other respondents, my lord.
Lordship, I'm appearing for respondent number 15, that is the Chief Secretary.
You are for respondent number 15.
15, yes.
And Mrs. H. Lalmalswamy,
Malswamy.
learned counsel, for respondent number 15. This contempt petition has been filed, drawing the attention of the court to the alleged non-compliance of this Honorable Court's judgment and order dated 11/4/2018, passed in review petition number 2 of 2018, arising out of WPC 123 of 2016. The facts of the case is that Marshwai, page number A, synopsis, A to A. Okay. Today, Mr. Lalfakwama, learned counsel for the petitioner, submits that though in terms of the court's order dated 11/4/2018, the respondents have invoked the provision of clause A of subsection 1 of section 24 of the Mizoram within bracket Land Acquisition, Rehabilitation and Resettlement Act 2016, however, the direction to the effect that the land acquisition award shall be made based on market value of the petitioner's lands to be determined as on the 1/5/2013 within bracket the date the preliminary notification under section 4 of the Land Acquisition Act 1894 was published in the Mizoram Gazette is totally in violation of section 26 of the said act, inasmuch as under section 26 the date
For determination,
ought to have been from the date of
date on which the notification was issued under section 11.
the date ought to have been from the date on which the notification under section 11 of the said act was issued.
My lord.
Give me the date.
26
26
May 2020.
26 5 2020 2020, correct?
2020, correct.
Stop. Per contra, Mr. Lalramenga, learned counsel for the respondent, submits that the Government of Mizoram Land Revenue and Settlement Department, by issuing the notification dated 26/5/2020, has fully complied with the directions passed by this court in the judgment and order dated 11/4/2018, and as such, there is no non-compliance, and as such there is no non-compliance or disobedience of the said order. Stop. MS so-and-so also submits that the order of the court dated 11/4/2018 stands compliant. Heard, perused, and then you write. Apt to reproduce the relevant portion of the order dated 10/7/2017 hereunder for ready reference. Paragraph 11, page 20, B to B. Apparent that this court, by the aforesaid judgment and order dated 10/7/2017, directed the state respondents, firstly, as to whether the land acquisition proceedings should be initiated and completed in terms of the Land Acquisition Act 1894 or by the Mizoram within bracket Land Acquisition, Rehabilitation and Resettlement Act 2016. Stop. Secondly, this court directed the respondent number 2, I, the Commissioner and Secretary to the Government of Mizoram, to cause necessary process to ensure that the decision is taken by the state government within a period of 1 month from the date of receipt of a certified copy of this order. Stop. Thirdly, this court directed the respondents that upon the decision of which act to be applied, comma, the respondents shall proceed with the acquisition proceedings and complete the entire exercise within a period of 5 months. Stop. This is completed, isn't it? Acquisition proceeding is
Yes, Your
completed.
Forward in submit only. Forward in submit only. My understanding is that the award, copy of the award has not been submitted.
No, but otherwise acquisition. Acquisition has been completed.
No, I mean, my understanding is that the entire process would be completed once award is passed.
My lord, I'm so sorry to say that I'm not aware of the fact that whether award has been completed or not.
Where is Miss Lalswam? She's
Maybe
disappeared. Maybe
Respondent
she
number
knows it.
15's counsel may be aware of it.
Lordship, even I'm not aware of it.
No, here it is given.
This is a
The award for acquisition of the said petitioner's land shall be prepared, deducting the amounts already paid. The whole exercise shall be performed by the Deputy Commissioner. This order shall not stand. So it appears.
It appears, my lord, but then let it be placed on record at least, because my understanding
I was
of
otherwise about to dispose it of, but
if that is placed, then I think we can.
can we have this tomorrow? Because this is of May 2020.
Mrs. Nirmal Somi, I think she.
Are you
she will
aware
be
of
able
what
to
has happened?
produce the
Because
No,
same.
Lordship, I'm not aware of it. Even
Can I
Miss Mary can.
Can I
Can
pose this
submit
matter
it.
tomorrow? All that.
Yes, Your Lordship.
Yes, because if you can inform the court that the acquisition proceeding is completed with the award and everything in terms of this May 2020 order, then nothing
can
survives.
close
I
it.
will close
Correct,
it.
right.
But right now it appears that that part of the instruction is not available. Because
Yes.
what has happened after 26 May 2020?
Yes,
That is not
Lordship.
there.
We can do it tomorrow.
You, Mashwai, don't cancel this order. You just type it and keep it, okay? Otherwise, now you write that a perusal of the order dated 26 May 2020 enclosed in the show cause reply filed by the respondent number 15 on 8 June 2023 indicates that the state government had taken the decision to apply the provisions of the Mizoram Land Acquisition, Rehabilitation and Resettlement Act 2016. Stop. It further appears that the state government has directed that the award for acquisition of the said petitioner's land shall be prepared, deducting the amounts already paid to the petitioners for their respective lends and subject to the government and submit to the government for approval and for payment to the petitioners afterwards. Stop. However, the respondents are not having the instruction as whether the same has been done or not. Let the instruction be placed tomorrow. List again. So and so.
Deeply obliged.
Obliged.
Item number 3.
My lord, for the respondent number 2, I have filed my affidavit in this morning.
You filed it.
Yes, my lord.
You have a look, Miss Valentina.
Yes, I have received, my lord. However, if I may be given some time
All right. As prayed for, first you write, MS Sangpui Learned Counsel for respondent number
2.
2
Yes, my lord.
submits that an counter affidavit has been filed today. However, the same is not on record. Let the registry verify and place the same on record. Stop. In the meanwhile, MS Valentina Learned Counsel for the petitioner seeks 2 weeks' time to file rejoinder to the said counter affidavit. Prayer is allowed. List the matter after 2 weeks on a date to be fixed by the registry.
My lord.
Item number 4.
Statutory deposits have been made.
Yes, Your Lordship. I've
When-
already
when?
deposited.
When?
If I'm not mistaken, at the time of filing the.
No, but it is not there, because if you can show me, I will admit it.
Lordship, I'll check it from the registry. And in the meantime, Your Lordship, I have served notice upon the respondents number
Respondent
7 and
is
8.
all right, but this is a statutory appeal. I would have admitted
Very
it.
true. Yes, yes.
So you can verify.
Yes,
I'll
okay.
take it after some time.
Sure, sure.
You wait. All the other matters. Just verify when you have
Yes,
made the
yes, Lordship.
deposit.
Item number 5.
If you want, have a look at the court's file, but I don't find any noting. Yes, Mr. Samuel. Yes.
Lordship, leading counsel have some personal difficulties for a
Who
time
is the
being,
leading
so
counsel?
Samuel Rambruato.
I have seen him. He was there in
No.
the court one.
No.
Here's another Samuel, my lord.
Yes,
Huh?
yes, another
This is a
Samuel.
different Samuel.
Yes, yes.
Oh,
So I pray kindly
I'm
that
sorry. I'm more familiar with the first name.
All right.
the matter may be put up after the consequent matter can come up.
Okay.
Kindly.
As requested on behalf of Mr. Samuel Lalramwata, the leading counsel appearing for the petitioner, appearing for the appellant, comma, which is not opposed by Mr. B. Lalramenga, Learned Counsel for the respondent, list this matter again on such and such date.
So black.
Date. Give a date.
Next week.
Yes.
Next week, my lord.
Kindly, Lordship, that the matter may come up after all this, the consequent matter may be heard for today. After all the consequent item may be heard on the last item, kindly.
You want this matter to be taken up today?
Yes,
You
Lordship.
just now said that your Mr. Samuel has some
Some,
difficulty.
yes, difficulties for time being, Your Lordship.
Then say Passover for the time being. Why are you making your submission so lengthy and confusing the court? Okay, cancel. Call it up at the end.
Item number
Simple
6.
Obliged.
submission, just simply say Passover for the time being. Yes, 115 days. Mr. Lalramanga, you are appearing in this matter?
Yes, my lord. I'm appearing for the sole respondent, my lord.
Yes,
And regarding IA, your lordship,
yes.
I'll not be filing any written objection because now interim order is still going on. and the proceeding has been stayed by way of interim order.
So you don't have instructions to object to the condonation.
Yes, it is for stay only, my lord, not
Huh?
condonation.
Not
It is for stay
condemnation, Your
order.
Lordship.
No, what about the condonation? Delay is condoned.
No,
This is
there's
item
not
6.
condonation, Your Lordship.
Is the delay condoned? Because
It is-
unless and until delay is condoned, how can the court take up the stay matter?
I think this is CRP, my lord, civil revision petition.
Yes.
Item 6. IA is
Oh,
for
I'm
stay.
sorry. I'm
IA
sorry.
is for
Yes,
stay.
yes, there is a stay.
Yes.
There is
So
no delay.
I will
No
not be
delay.
filing any written objection
You
because
will be filing.
I will not file, my lord, because it is on the verge of final hearing, in the sense that, your lordship, it could be heard, finally heard.
The CRP.
Yes, CRP.
What is the issue involved?
My lord, despite the arbitration clause, which says that either party shall not commence any civil suit without first going to the arbitration proceedings, the respondent herein has filed a civil suit. So we are objecting the filing of the civil suit before the senior civil judge. But the the landed senior civil judge say it is the case is maintainable. So the order is challenged before this honorable court. And this IA is with regard to the stay of the proceedings before the landed senior civil judge.
An application for rejection of the plaint was filed. That was
Actually, it was not application for rejection.
Then?
Just to simply dismiss the case. Then that cannot be done under CPC, my lord. Let them apply for rejection of the plaint. Had any reason they could cite, but that was not the application. I may take a lordship to page.
My lord, there, if I may, there was no separate application for rejection of the plaint. We are objecting the maintainability of the
yes,
suit.
but then there is a procedure under the code. There is
Yes.
a provision under which you can make an application for rejection of the plaint.
Order 7
My
Rule
lord,
11.
My lord, we have objected by submitting a preliminary written objection, and
That is
preliminary
not the
hearing was conducted before the learned trial court. Then we say that the case is not maintainable due to arbitration clause. We say that no civil suit shall be commenced by either party. So
But that was rejected.
that was rejected. So
Which
we
is-
are challenging the said
order is the rejection order is
21/4/2023.
21/4/2023. Now you come to that Roman page, Roman 3. I have heard the parties read. Yes, please read.
My lord, page
And this
23.
this is under 115.
CRP.
The petition is filed under 115.
Yes, my lord, I think it is under. This
This
is 115.
application
Yes,
is
your lordship.
115.
Read with 227.
Because that means you have to show that there is a jurisdictional error, because 115 is only concerned with jurisdiction.
My lord,
Read.
page 14 of my,
No, you read that I have heard the parties at length. Please read from them, Mr. Counsel. Are you having any difficulty in understanding the language? the
page
court is
23,
speaking?
right, your lordship?
Huh?
Page number 23 of my petition. Yeah, I mean, so, no. My lord, I'm reading the IA.
I
I'm
Yes.
of the impression that the IA should be taken up first.
all right. Which page in the IA?
Page 23, I
20?
suppose 23. 22 is the impugned order.
Yes, read
It
from
starts
23.
from page 22.
Yes, I have heard the parties.
I have heard the parties at length on perusal of the plaint that is filed by the plaintiff para number 1 to 11 talks of the issues in connection with the MOU that was executed between the plaintiff and the defendant. In para number 11 of the plaint, it is seen that Akas and Associates chartered accountant had made an audit of the expenditures that had accrued out of the MOU, wherein there had not been any issues with regard to the expenditures, and thus states that the account statement proves that the MOU had been honored. Furthermore, additional documents have been submitted by the plaintiff today, which had not been objected by the defendant. The additional documents pertains to completion of work, that is WCC dated so and so. From plain reading of the these documents and on perusal of the documents that had already submitted, it would appear that the MOU that was executed between the plaintiff and the defendant had already been completed. However, if any dispute arises as between the veracity of the documents, that it is the opinion of this court that the same may be proved by way of evidence. Now coming to
Your prayer is to stay this order.
Yes.
What is the stay application that you have filed?
this very IA number 101.
There is no question of staying this order. In fact,
Interim stay,
in fact, this
Your
court is
Lordship.
of the view that your revision petition itself is not maintainable. What is the jurisdictional error in this order?
My lord-
And if you have, if you wanted that the plaint be rejected, then you should have filed an application under Order 7 Rule 11. Where is your application under Order 7 Rule 11?
Yeah, if Your Lordship kindly come to page 14.
40
14.
14.
This is a memorandum of understanding signed by the parties. Page 14 is the relevant page.
Yes.
It is from clause 10.1 to 10.2. 10.2 is very relevant, Your Lordship.
10 point?
10.1. Shall I read, Your Lordship?
It will be referred to an arbitral tribunal.
My Lord, before commencing any civil suit.
Yes. So there is a, then for that you have the relevant provisions. Have you applied under the relevant provision? Section, there is a section,
Order 7 Rule 11 is the rejection, ma'am.
no, not only rejection, if it can be referred to the arbitration. There is some,
Arbitration, yes.
I think there is a provision also.
Yes, my lord. Section 9 something.
I think section 9, that's right.
The section, no, I think 89, my lord. Section 89.
No, 1 second. Let's see, Order 7 Rule 11. So, Mr. Counsel, if I have understood your case correctly, according to you, the suit is not maintainable
Because of this
because there is an arbitration clause.
yes.
Correct?
Yes.
That is the ground. Now, you have not filed any application under Order 7 Rule 11, correct?
Right.
You have merely made an oral submission.
We have stated in the written statement. Written statement.
And you have
Then before further proceeding of the case, we usually have
You
the
made an-
preliminary hearing.
you made an argument,
Yes,
and that was rejected.
that was rejected. The rejection order
So
was
there is no
under challenge now.
application or petition for taking up the maintainability. Is there an application? Did you file a petition that for
My lord,
deciding the maintainability?
We objected only by way of submitting the written statement
Okay. So that is only in the WS.
in the WS.
Your lordship, WS has not yet been filed.
WS means
Yes, I think my learned friend has mistaken
objection.
with making that.
I cannot hear if both of you speak at the same time.
Preliminary objection we submitted, not the full-fledged written statement.
Or you just filed an objection.
Yes.
Preliminary.
And on that basis, it was
hearing
decided
was
that
conducted.
they rejected the ground.
Yes.
Yes, and we are directed by the learned court to
File
submit
WS.
written statement.
So file WS.
Our contention is, my lord.
No, I have appreciated your contention, but you are not following what is coming from the court. There is a procedure. Ultimately, you are guided by the CPC, correct? Yes or no?
My lord.
Are you guided by CPC or not?
Yes, this application itself is under the CPC.
Please come to Order 7, Rule 11.
My lord, fortunately, I'm
You're not
doing-
carrying the CPC?
Yes, yes, your lordship.
Why? Basic courtesy is to carry the relevant books, right?
Yes.
They're not even carrying it. The other day also in 1 or 2 cases this court has observed. It's time for you to sensitize the bar, Mr. Malhotra.
My apology for this, because, my lord, I am of the impression that my learned opponent will be filing the
Be that
objection
whatever,
only.
whatever
So
be
that
it.
is why.
When a matter is listed before the court, you have to be mindful.
That's right, my lord.
You can take the matter seriously. It may be just whatever. At least have the courtesy of carrying the relevant book. Yes, I think Mr. Lalramanga has given you his
Yes, I
book.
have given it.
Lordship.
Yes, please read now. Please read Order 7, Rule 11. Mr. Lalramanga.
Rejection of plaint.
Yes, yes.
The
read.
plaint shall be rejected in the following cases: where it does not disclose a cause of action, where the relief claim is undervalued, and the plaintiff, on being required by the court to so correct the valuation within time to be fixed by the court, fails to do so; where the relief claim is properly valued, but the plaint is written upon proper insufficiently stamped, and the plaintiff, on being required by the court to supply the requisite stamp paper within a time to be fixed by the court, fails to do so; where the suit appears from the statement in the plaint to be barred by any law.
So, under D, according to you, the suit is barred because there is a arbitration
Arbitration
clause.
clause.
Correct? So then you ought to have filed this application. You have not filed it. There is another provision for the Mr. Lalramanga.
My lord.
When there is an arbitration clause, there is a provision here.
I think that section 89, which
Section?
your lordship is referring to, yes.
Section?
Section 89 of the CPC, my lord. I don't know whether your lordship is referring to this.
No, not this. Okay, Arbitration Act. If I am not mistaken, there is a provision which says if there is an arbitration agreement, that has to be brought to the notice of the court, and the court has the discretion of referring it to the arbitrator.
Yes, it is
And
there.
in
my
that case, I think the original.
lord. Yes, there is, your lordship is talking about section 8 of the Arbitration Act. my
Yes, give me the Arbitration Act.
However, your lordship, what I would like to submit is that this particular agreement is the relief which I am claiming in the district in the lower court.
Is not covered by the.
Yes, it's not covered by the agreement.
That is
yes.
that is a different matter. Let us understand.
Yes, my lord.
First.
Section 8.
I'm sure you're not carrying the Arbitration Act.
I have, my lord.
You have.
I'm carrying the arbitration.
Oh, that is
arbitration
wonderful.
act.
Very well. Now come to Section 8. Section 7 is arbitration agreement, and then Section 8.
Section 8, your
Yes,
lordship.
please read.
Power to refer parties to arbitration where there is an arbitration agreement. A judicial authority before which an action is brought in a matter which is the subject of an arbitration agreement shall, if a party to the arbitration agreement or any person claiming through or under him, so obliged not later than the date of submitting his first statement on the substance of the dispute, then notwithstanding any judgment, decree, or order of the Supreme Court or any court, refer the parties to arbitration unless it finds that prima facie
Yes.
no
What do you
valid
want-
arbitration agreement exists.
What do you understand from here? You have not even made an application under Section 8
No, my lord.
because your whole ground is that there is an arbitration clause.
Right, your lordship.
You could have come under Section 8 or under Order 7, Rule 11. You have not done under any of them.
My lord.
Are you following what I am saying?
Yes, yes, Your Lordship. We are not. We have not submitted any.
You have not. I
But-
don't find anything wrong. Therefore,
But my
I
Lord,
think
my humble contention and submission.
you are at liberty. If you feel you can you can come up under Section 8. That is your
My Lord.
prerogative. But as far as this court is concerned, I don't find any merit in your revision petition. I'm taking up the main revision petition
But
and
my
I'm
Lord,
dismissing it.
My Lord, one thing, the respondent is still now participating in the arbitration proceedings. He has submitted an application before the Kolkata High Court. The order is available
But
here,
you have
Lordship.
heard the submission of Lal Ramenga. He says that the issue involved in the civil suit is not covered under the arbitration.
It is exactly covered.
But Mr. Counsel,
order
if
has-
you do not approach the relevant court with the under the relevant provision of law, how can this court help you? You are before this court in a revision petition where your objection taken in your in the written objection was rejected.
My Lord, with
You are
regard
against
to-
that.
My Lord, with regard to the said MOU that we are saying, the Kolkata High Court has appointed an arbitrator in the present case. The respondent himself has approached the Kolkata High Court. If I may place the order, Your Lordship.
No, I'm not looking into all that.
And
I'm-
that is different matter, man.
I am only
It's not-
concerned
this
with
is not different matter,
I am
my lord.
only concerned with the order dated 21/4/2023. This court is exercising the revisional jurisdiction. It's a limited jurisdiction. I don't find there is any jurisdictional error.
But there is, my Lord.
You have already shown it. Your ground is that there is an arbitration clause. I will deal with it. Anything else besides that point?
My Lord, in respect of the MOU that we have stated in our petition, and that has also been stated by him in the plain before the civil court, the arbitrator has been appointed, and for termination and for new appointment of the new arbitrator, the respondent himself has approached the Kolkata High Court by filing a
Mr. Lal Ramenga,
number
in that
1 of
proceeding,
2023.
you have given any reply to that objection?
He has participated, my Lord.
No, my
I
lord.
have the document. If I may place before
Because
your
that was-
Lordship.
No, I'm not taking documents like that.
My lord, if I
so,
may,
my
my lord.
Lord, in
Yes.
that case,
If I may, your lordship, in that order which has been challenged by the learned counsel, it is clearly written at the last paragraph that, your lordship,
Yes.
second last paragraph, towards the end of paragraph, I am referring to the CRP, my lord, petition. It says that now, towards the end of this para, my lord, now coming to para 12 of the plaint, the first paragraph states as follows: the plaintiff and defendant further corroborated in handling civil jobs at Marpara substation under the project handed by PGCIL Corporate. This is different case, different work. And I have stated clearly in the plaint that MOU has not covered this particular work, out of which my claim is based.
Where in your plaint?
My plaint para 12 and 13 at page Your
Where?
Lordship, page
Page?
16 of the petition. Sorry, page 18. Starting from page 18, this is para 11. Para 11, this table shows about how the payment had been made in respect of the MOU. There are two particular works covered by the agreement, my lord. And now I'll come to para 12, that is page 20, my lord. May I take a lordship to page
Yes.
20?
Under the work involved here is under Sterling Wilson Private Limited.
Exactly. Different
And that
work.
MOU is in relation to the
Two other works.
Marpara substation.
Not Marpara yes, my lord. Marpara substation is the other work upon which the present claim is based.
The MOU that has been
MOU is for erection of that tower, mobile tower. But this particular work, which is referred in para 12, is Marpara work, my lord. And this amount has been, the reason why I'm claiming is that this excess payment, which should be adjusted from this work itself, and it is not covered by the MOU. So, my lord, unless and until they file written statement, law is very clear, as the Honorable Apex Court had also stated that, Your Lordship, in order to reject the plaint, only the contents of the plaint should be taken into consideration. And they cannot, their objection,
All
wherever
right, I have heard both of you.
My lord, if I may, if your lordship is of the opinion that the court will not receive this document, I may be allowed to submit additional documents incorporating all these things to show that he has participated in the arbitration
Mr.
proceeding in
Mr.
respect of the
Counsel,
MOU that I
Mr.
have said.
Counsel, you have not filed a WS
Yes.
number 1. From the plaint, it appears that there are 2 projects. The MOU that you are referring to, which has an arbitration agreement, relates to the other project.
No, my lord.
We don't know. You see, it is at the beginning. You have not filed WS.
It is very clear from
Mr.
the
Counsel, you have to
document.
understand that this is not a writ court.
My lord,
You have to understand.
my lord.
And you have to also understand that you are before a very limited jurisdiction. You have not even filed an application under the appropriate provision of law. Where is the application under Section 8 of the Arbitration Act? Have you filed? Because that is your ground.
No.
Just because there is an arbitration clause doesn't mean that the suit will be not maintainable.
My
It
lord,
can be referred. Where is your application under Section 8?
what I am trying to submit before your
Number 1,
lordship
there is no
is,
Section 8 application.
Right.
Number 2, have you filed an application for rejection of the plaint?
no, my lord,
Have you filed it?
we have submitted the preliminary objection before the learned
That
trial
is not
court.
the way. This is not some labor court tribunal where you file an objection and preliminary issue will be done.
My lord,
It has to be, the court provides how things has to be done. If you are making a case that your suit is barred by the law under some provision of law, you could have filed a rejection application. You have not done that.
my lord, I understand, my lord, but if I may humbly submit before this honorable court that arbitration proceeding is between the parties as of now. If I may be allowed to submit this by way of additional documents in
Not
respect
in
of
this
the
court.
MOU itself.
When you file your WS, you may bring it.
My lord, he is still having liberty to file application under Order 7 Rule 11 before the trial
May
court.
I be allowed, my lord, kindly to submit these documents to show that
Not before this court, appropriate forum, Mr. Counsel. As far as this court is concerned, the veracity of the order is under challenge. You see, even if for some reason this court finds no merit in the revision petition, you still have the other remedies open before the civil court. You bring those documents before the civil court under the appropriate provision of law. This is what the court is saying.
Yes.
Have you followed? This is not an equity court. I'm not foreclosing your the argument that you are making, but you have to come up with an appropriate application,
my lord,
not in this
my
manner.
lord, before the learned court, the learned trial court, and before this honorable court, also they stated that memorandum of understanding between the parties has already been complied with and completed.
It's
But
very
in respect,
difficult if you keep repeating your submissions.
that is their submission,
You
my
are only
lord.
repeating your submissions, Mr. Counsel. You are just not replying.
That is not my submission, that is their submission before the trial court also. But these documents clearly reveals that in respect of the MOU, there is an arbitration proceeding
All right,
at Kolkata.
please write. Heard, Mr.
That's
in the
the
CRP, in the main. Mr. Lalsang Liana.
Lordship,
Kyang Te,
Right.
Learned Counsel appearing for the petitioner. Stop. Also heard Mr. B. Lalramenga, Learned Counsel appearing for the
Sole respondent. my
sole
lord.
respondent. Stop. The civil revision petition has been filed under section 115 of the Code of Civil Procedure 1908, assailing the judgment and order assailing the order dated 21/4/2023 passed by the Court of Learned Senior Civil Judge 4, Aizawl Judicial District, Aizawl, in civil suit number 7 of 2022, whereby the trial court was pleased to maintain the civil suit with a direction to the petitioner to file written statement stop. Councillors, please take your seat. The facts of the case is as follows. A to A at page A of the synopsis. Mr. So-and-so, learned counsel for the petitioner, submits that in view of the arbitration clause in the MOU dated 11/2/2017
Lordship, and the second MOU is also
and 19/3/2018,
right, Your Lordship.
comma, the suit filed by the plaintiff stroke respondent is not maintainable, and accordingly, upon receiving summons from the trial court, a written objection
Preliminary written
a written objection was filed before the trial court, wherein the issue of maintainability of the suit was raised as a preliminary issue. Stop. Correct?
correct, my lord.
Stop. He accordingly submits that the order of the trial court rejecting the said preliminary, rejecting the said issue raised as regards the maintainability of the suit in view of the existence of an arbitration agreement is totally erroneous, and the same is ought to be interfered with by this revisional court. Stop. Per contra, next para. Per contra, Mr. B. Lalramenga, learned counsel for the respondent, submits that the order that there is no jurisdictional error whatsoever in the order of the trial court dated 21/4/2023, holding the suit maintainable, and therefore the said order of the trial court warrants no interference whatsoever from this court while exercising revisional jurisdiction under section 115 of the CPC. Stop. He further submits that the petitioner stroke defendant has neither filed any appropriate application under section 8 of the Arbitration Act so and so, nor filed any application under Order 7, Rule 11 CPC for rejection of the plaint, and therefore cannot in this revision petition argue that the suit is not maintainable due to existence of the arbitration clause in the subject MOUs. Stop. He further submits that the dispute raised in the suit is not covered under the arbitration clause, under the arbitration agreement. Stop. Perused, heard and perused. Then before proceeding with the before proceeding with the arguments made by the contesting parties, apt to refer to the plaint filed in civil suit number 7 of 2022. Stop. It appears that the said suit has been filed for damage compensation amounting to rupees 1.50 crore against the defendant for loss of profit, goodwill and reputation of the plaintiff. Stop. Paragraph 2 to paragraph 12 of the set of the plaint is reproduced here under for ready reference. Yes, where is your objection? That written objection?
88 to 91.
Page
88 to 91.
80.
88.
Sorry,
88 to 91. 88 to 91.
apt also to refer to the did I give you the page number for the plaint? That you will find at page 15. Okay, and apt also refer to the preliminary objection filed by the appellant stroke defendant, which is reproduced here under for ready reference. From paragraph 2 to paragraph 1 to paragraph 4, page 88. It appears that the sole objection for maintainability of the suit is the existence of an arbitration agreement in the MOU dated 11/2/2017 and subsequent MOU dated 19/3/2018. But this arbitration clause you are referring is only, I think, in 11/2/17.
Two MOUs.
In the second also there is an arbitration clause?
Yes, exactly.
Okay, okay.
Page 38
Okay.
to 39.
However, it appears that no application under Section 8 of the Arbitration and Conciliation Act 1996 was filed before the trial court. Stop. Section 8 of the said Act is reproduced hereunder for ready reference. It is correct that where dispute is referable to arbitration, parties cannot be compelled to take recourse to in civil court. Stop. However, an appropriate application in this regard has to be brought before the trial court. It appears that in the present case, no such application under Section 8 was filed by the appellant defendant for the trial court. Further, it appears that I think I will not say much. What I will do is, I will give them the liberty to make an appropriate application. Because if I interfere this, then they will have difficulty.
Yes.
I don't want to go into the merit right now.
Yes, my lord.
And my lord,
See, I'm keeping the
yes,
question
yes,
open,
my
Mr.
lord,
Counsel,
only one request.
and this is in your favor. Yes,
Only one request. My submission with regard to the appointment made by the Kolkata High Court.
I
may
am
be
not going
reflected.
into all that, Mr. Counsel. If you want, I can dismiss it on merit, but that will be difficult for you. I'm giving you the liberty.
My lord.
In view of the above, in the ends of justice, this court deems appropriate to dispose of the instant revision petition by giving a liberty to the petitioner stroke defendant to file appropriate application before the trial court in accordance with law. Stop. To that extent, the order impugned in this revision petition stands interfered with. Revision petition disposed of. In the stay also you say, in view of the order passed in the CRP, the stay, the I stands disposed of.
Deeply obliged.
Interim order passed earlier will also automatically.
Sorry?
Interim order
If
passed earlier.
interim orders passed earlier, accordingly stands vacated.
Much obliged.
Both disposed of. 1004.
Yes.
Where
I'm
is
for
the,
My lord,
where's the petitioner?
Miss Mary.
Miss Mary?
yes, my lord.
Oh,
My
this
lord,
is
it's an
state.
application filed under Section 5 of the Limitation
Yes,
Act.
filed by the state.
Yes, my lord.
By the
1436.
state.
Yes, any
Yes, my lord.
serious?
My lord, I
Objection?
have to file a written objection, my lord. So
What
may I
written
seek,
objection? When did you receive notice, Mr. Lal Ramenga?
my lord, I have received earlier.
Yes.
So
then
I am preparing it, your lordship. So if
what are you preparing? It's a condonation application. What objection are you preparing for so long?
sufficient cause is not made out, my lord. I'll
Not
just
made out.
Yes.
Let us find out. If not made out, we will not. This court will not condone.
Or-
If
my lord-
it is made out, this court will condone. Yes,
lord,
Miss
if-
Mary. What is the ground of delay?
My lord, the ground of delay is basically due to a COVID outbreak. There was a misplace of file, the communication that is made between me and the concerned authorities. So it seems that it was
There was miscommunication between you and the authority.
Yes, the authorities.
My lord, if I may, your lordship, with apologies, it may come up tomorrow then, my lord.
Why? What
Then I
will
just-
change overnight?
So, my lord,
You will file the objection tomorrow.
yes, I'll
But
be filing my
tomorrow there
objection.
are a lot of matters fixed, and tomorrow there is some other engagement also.
Or if
official.
possible, my lord, next Monday.
So I'm not sure. No, I'm taking this. What? It's a state objection, and it appears that there was some miscommunication, and the file was misplaced, Miss Mary.
It was not not the file, the communication, the letter.
Which paragraph?
My lord,
I have noticed here the respondents in condonation cases takes the matter very seriously, huh?
It's because
Yes.
So
your lordship.
you have to understand that this is basically it's a discretion which the court has to
I
exercise,
understand.
and it is in a positive manner.
I understand.
So you definitely you have a say, you have a right. If there is something from where you want to show that the other side has adopted some dilatory tactics or they have been not bona fide, you can definitely point out. But here, because there are some lapses, doesn't mean that each and every lapses you will be arguing. This is after all a discretion.
I understand,
and it's
my lord.
condonation.
There is a clear lethargy in this particular case, my lord.
So show it. You can show it.
if-
What affidavit you will have to file for showing it?
It may come up tomorrow, or if not possible,
No,
my lord,
right now.
this Friday.
Right now,
Before your
itself.
lordship, then.
Which paragraph?
my lord, I have mentioned in paragraph number 6 that the matter was put on hold due to outbreak of
Paragraph
COVID-19.
6.
Then, yes. And my lord, the subsequent paragraph.
It looks all okay, but anyway, I'm reposting it on Friday.
My lord.
No further adjournment.
Yes, my lord. In the meantime, I'll
You
be
want to
filing my
file something, you file it.
Yes, my lord. Much obliged.
Friday, Miss Mary.
Yes, my lord.
Relist Friday. To enable Mr. B. Lalramanga to bring on the objection on record. However, no further adjournment shall be granted in this matter.
Highly obliged.
Item number 8.
1896. This is
Lordship, yeah, that one.
that matter, date of delivery.
Yes.
Yes.
With due respect, Lordship, I've gone through, I've checked the record, and admittedly, we don't have such record. And now I am in a position that I have two options, Lordship. I have informed also. If your Lordship may kindly be allowed to withdraw, that is one option, and I have already informed also.
All right.
Otherwise,
Withdraw. If you want to withdraw, you withdraw. You
Yes.
don't need my permission. I will record your endorsement and I will say it's withdrawn.
Yes.
You are withdrawing what? The
appeal.
The appeal.
Yes.
All right. So in
Or
the,
otherwise, argue the matters.
all right. In the IA, but this order will be in the RFA or in the IA?
No, Shubha. No, Shubha, it'll be in the IA and then
Alright.
in the RFA in
Yes.
consequence of the order
All
passed.
right. In
will
IA,
become-
you write, heard Mr. J.C. Lalung Sanga, Learned Counsel for the applicant, stop. Also heard Mr. A.R. Malhotra, Learned Counsel for the respondent, stop. Mr. J.C. Lalung Sanga, Learned Counsel for the applicant, submits that he has received instructions not to press the instant interlocutory condonation application. and accordingly makes an endorsement to that effect. Stop. In view of the aforesaid endorsement made by the learned counsel for the applicant, the instant interlocutory application stands dismissed for withdrawal. In the RFA, in view of the order passed in IA so and so, the RFA stands dismissed.
Much obliged.
Both disposed of, huh?
Item number 9.
May it please your Lord.
Yes, Mr. Alpagwala.
My Lord, this is a bail application under Section 21B of the NDPS Act.
LC. Bharatiya Nagarik Suraksha Sanitha. Bharatiya Nagarik Suraksha Sanitha. Yes.
Your Lordship has previously rejected our bail application.
This is the second time.
This is the second time. On the
What
ground.
change of circumstances?
Now, before the investigation was going on, now
Investigation is completed.
out of 6 prosecution witnesses, 4 witnesses have been examined so far.
Yes.
Now, your Lordship will see that I've been in custody for more than a year now.
Huh?
I have been in custody for more than a year.
More than a year.
For almost a year. I'm sorry, for almost a year. That is 3 to 9 days.
3?
To 9 days.
Yes.
Yes, on date.
That alone cannot be a change of circumstances
No,
for
no.
second bail,
I-
second application, Mr.
I'm
Alpagwala.
obliged to submit that I'm in custody for about 329
But
days.
what change
The
circumstances?
change of circumstances, your Lordship will see, is prosecution witness 1, 2, 3, 4 have been examined. Prior to this bail application, your Lordship has rejected our application on the grounds that investigation is still going on. I'll take your Lordship to your Lordship order, page 18 to 20. The relevant portion is at page 19, para 7.
Yes.
I'll read this, my Lord.
Yes.
It appears from the case diary that the investigation is going on and the contraband articles had been seized from the residence of the accused petitioner since the investigation is yet to be completed. And from the materials available on record, it prima facie appears that the accused petitioner has committed the offense and hence I am not inclined to release the petitioner on bail at this stage. Now, subsequent to this order, my Lord, charge sheet has been submitted and prosecution witness 1, 2, 3, 4 have been examined. Your Lordship will see how the prosecution case has been made up by the present excise. Now, my grounds for appeal is at page 5.
Yes.
At subclause 4.
Yes.
My Lord, when the applicant was arrested at one place called Durtlang Leighton by the excise and narcotics personnel for trying to sell 2 soap cases containing heroin, there were no reliable civilian
It's
witnesses
not a
present.
rehearing, Mr. Alpagwala.
My Lord,
This is not a rehearing.
no, this is the first time we have to appreciate the evidence.
No,
Your
no.
Lordship does not have a chance to appreciate the evidence when Your Lordship take up the
These
first.
matters can be taken up at the trial.
Your
No
Lordship-
change of circumstances, Mr.
No.
Alpagwala.
I understand.
How
what
many
your-
prosecution witnesses total, Miss Linda?
6.
Huh?
6 of them.
Total 6.
Yes, 4 is already.
Yes, the trial is going on in a very speedy manner.
No.
Yes, of course. Out of 6, 4 is already examined. 2
Now
are left.
I have been in custody for about 329 days.
That alone cannot be a ground. This is under
Now-
the NDPS Act, Section 37, Mr.
It's,
Alpagwala.
no, the rigors of Section 37 is not attracted
This is
here.
B.
This is B. That is
But-
why I'm forcefully
But that's
making
all
my
right.
submission.
You see, the only problem is this is the second time you have come.
The second time.
The law is very clear. When you come second time, number one, it is not a rehearing.
It's not a hearing.
Correct. It's not a rehearing. It's not a review. All that you need to show is that after the rejection, there must have been some change in the circumstances,
That is
which requires
That is exactly the
But
point
where is
why.
that? That's
no,
what I'm asking. What is the change? You are
Change-
you are referring to all these procedural things.
No, the change is that your lordship will see witnesses have been examined. Prior to this bail application, it was only at investigation stage.
Yes.
Now, as your lordship will see, PW number 1234 have been examined so far.
Yes.
Now, what I'm trying to impress upon your lordship is that I was going to show your lordship what the prosecution witnesses have deposed before the court.
Two are yet to come.
Two are yet to come.
Is this a stage where this court will go into all this? There are still two more witnesses.
No, your lordship is a,
Witnesses, the prosecution deposition is not over.
your lordship is a staunch supporter of bail is rule. Jail is an exception. Your lordship has mentioned before
That we
this
have
court as
already
well.
rejected once. This is the second time.
This is the second time on a new grounds.
No, but that can't be. You can't be simply show me from from four witnesses and say nothing has come out. Two are still there.
Two are still there, and one is.
Evidence stage is not completed.
These are all the material witnesses. These four witnesses are only the material witnesses.
Mr. Lalfagwala,
I'll-
maybe
no.
if you would have come after closing of the evidence, this court could have appreciated what you are trying to say.
At this stage, may I place a citation
Yes, yes.
of the Honorable Supreme Court?
You may.
Your Lordship will see at page 127, para 22.
Page?
27, 127.
Yes.
Para 22.
Yes.
I'll read this with your Lordship
yes.
permission. In other non-bailable cases, the court will exercise its judicial discretion in favor of granting bail subject to subsection 3 of section 437 CRPC if it deems necessary to act under it, unless, this is important, my lord, unless exceptional circumstances are brought to the notice of the court which may defeat proper investigation and a fair trial. The court will not decline to grant bail to a person who
Is this in the context of a second bail?
Yes, obviously.
case?
No, I mean, this is a case where the punishment is...
No,
is-
what I'm saying is that the observation made in 22 is in the context of first bail application
Oh, no,
or
that-
second bail application.
That is not the case. This
I am
is,
asking a
No,
question.
that is not the case.
Huh?
That is not the case.
No.
That is, it is not in the context of second or first bail.
All right.
This
So
is the
here
case.
in Guru Charan Singh, this was the first time.
This is the case where the issue before the Honorable Supreme Court is when the punishment is not with death or imprisonment for life, the court will not decline to grant bail. Now, my lord, why I am pressing this forcefully before your lordship is that this is not commercial quantity. This is a intermediate quantity where the rigors of section 37 of the NDPS Act does not come into play. Now, another citation with your lordship permission, which I may place before your lordship.
One second. In the first round, you were not the counsel.
The first is another counsel
Yes.
who is now currently in ill health. Now, your lordship will see that 2012 1 SCC 40,
Yes.
page 63, para 40.
Page
63 starts from, I'll read from para 40.
Yes.
These are the principles.
This is also in the context of first bail.
Yes. This is Sanjay Chandra versus CBI.
First bail.
Yes. I'll
Yes.
read this, my lord.
Yes.
The grant or refusal to grant bail lies within the discretion of the court. The grant or denial is regulated to a large extent by the facts and circumstances of each particular case. But at the same time, right to bail is not to be denied merely because of the sentiments of the community against the accused. The primary purpose of bail in a criminal case are to relieve the accused of imprisonment, to relieve the state of the burden of keeping him pending the trial, and at the same time to keep the accused constructively in the custody of the court, whether before or after conviction, to assure that He will submit to the
So where are
jurisdiction.
the depositions of these 4 witnesses?
My lord. PW number 1 is 47 to 48.
40.
7 to 48.
Anything has come against the petitioner?
Now, this, on reading this prosecution evidence, it will come out that their case has been fabricated against me because the place of seizure at one point does not indicate that they have seized 2 soap cases from the applicant herein. Your Lordship will see at page 28.
What is the name of the petitioner? Lalin
Nkuala.
Nkuala. Nkuala, that is the petitioner, na?
Petitioner. If your Lordship will allow me, I'll just take your Lordship first to page 25.
Page?
Page 25.
No, it appears that in the evidence implicating the witnesses have implicated you.
Yes, they have implicated.
They have, but now how you cannot ask a bail court to now appreciate and reappreciate these evidences,
No.
which are also not yet completed.
I'm not-
Correct?
I'm
That
not
cannot
praying.
be.
I'm not praying that.
Yes, Miss Linda, what do you have to say?
My lord, bail is the discretion of the court. That is true. But
See,
my lord, we have to
no,
see
but
that.
one thing which in fact Mr. Lalpanjwala is also, I'm hinting it. You see, I have already exercised my
Yes,
discretion.
that's what I was.
And I
yes,
have
my lord.
already
This is the
rejected.
second round, yes.
Now this is the second time that this bail has been moved. Now when it comes for the second time, it further, the entire parameters becomes very narrowed down,
Yes.
correct?
Yes.
So
Unless
only
there's a
thing has to be
new
seen is that if
evidence.
there is some changed circumstances. Now it appears that yes, at that time the investigation was going on. That was also one of the reasons why this court did not grant bail, because this
Yes.
court perhaps didn't want the investigation to suffer. Now it appears investigation is complete and the trial has started.
Yes,
Out of
almost
the six,
completed.
almost completed. Out of 6, 4 has already been examined. And it also appears that from the testimony of these 4 witnesses that implicating materials are
Yes,
coming out. They are implicating. Whether they are correct, not correct, appreciation. This court is not going to do it right now because this is, it will affect the trial
Yes.
and it is not yet complete. So keeping that in mind, I don't feel this is the time when, because it's going to complete. How much time
Yes,
do you think it should be? How much more time do you think it will take?
My lord, just 2 witnesses and they are from Aizawl itself.
Who are these 2 witnesses?
PMFC.
My lord, JMFC, she is the judicial magistrate.
Who must have recorded the
Yes.
statements and
And another one is
FSL.
the FSL. So they are both from Aizawl.
so, but any antecedent, criminal antecedent?
It's not written.
No criminal
No,
antecedent.
no previous.
And this is not under 37.
Not under 37.
Now, since almost the main material witnesses have been examined
Yes.
and he has already been in custody for last 3 to 9 days, keeping that in mind, maybe this court can grant the bail, Ms. Linda.
That is
Because you
yes,
see,
the discretion of the court.
that is why, how will this court exercise the discretion? This is why I'm expressing what is in my mind. 329 days, material witnesses examined, 2 formal witnesses are left, correct?
Yes.
And I'm from this place, Aizawl.
So I think keeping that in mind, maybe in the peculiarity of the facts and circumstances, and specifically coupled with the fact that there is no antecedent. If it was he was involved earlier also in similar offense, perhaps that would have gone against.
Yes.
My
All right.
objection is only to that part that trial is almost completed.
Correct. That you're not objecting. You are saying that
Yes, ma'am.
trial almost, so a speedy trial is going on.
Yes, ma'am.
Okay, very well. Heard Mr. C. Lalfakwala, learned counsel for the applicant. Stop. Also heard MS Linda Famwell, learned PP for the state respondent. Stop. This is an application under, this is a second application under section 37 of the NDPS Act 1985, read with section 4831 BNSS 2023, seeking enlargement of the applicant accused I. Lalenkwala on bail in connection with, where you have not said it in your
In my prayer, page 12.
cost title.
In my prayer is there.
Why it's not there in the cost title?
The first page is there, my lord.
Okay, okay. In connection with EX within bracket N number 284 of 2023, registered under section 21B of NDPS Act 1985. Stop. The case of the prosecution is that on 17/10/2023 at 7 p.m. upon receiving information, page 18, OP, page 18, paragraph 2 to paragraph 3, A to A. Okay. Pertinent that this court by order dated 15/12/2023 had rejected the first bail application of the petitioner on the ground that the investigation is yet to be completed and that from the materials available on record, a prima facie case appears to have been made out against the petitioner. Stop. Mr. C. Lalfakwala, learned counsel for the petitioner, submits that in the meantime the investigation has been completed and upon submission of charge sheet, trial has commenced, wherein out of the 6 prosecution witnesses, 4 witnesses who are material witnesses have already been examined. Stop. He further submits that the petitioner has been languishing in the jail since almost last 329 days. Stop. He accordingly submits that in view of the changed circumstances, the prayer for bail ought to be allowed by this court. Stop. Per contra, MS Linda so and so submits that the trial has progressed substantially and in fact is at the fag end. Stop. Correct?
Yes, ma'am.
I have give my heard and perused, including the case heard and perused materials relevant, and then say it appears that upon the investigation being completed and submission of charge sheet, trial has commenced, wherein out of the 6 prosecution witnesses, 4 prosecution witnesses has already been examined. It further appears that the 4 witnesses of the prosecution who has been examined are the material witnesses. The remaining 2 witnesses are formal witnesses, one judicial officer and the other is a forensic expert. Stop. It further appears that there is no antecedent and there is no adverse antecedent available against the petitioner in the records. Stop. It further appears that the petitioner has been languishing in the jail since last 329 days. considering the length of delay and that the trial is almost coming to an end. No, don't say that. Considering the length of delay and the peculiarity of the facts and circumstances of the instant case, comma, this court considers in the interest of justice to grant bail to the petitioner. Stop. Accordingly, it is provided 50,000 rupees.
Bail bond.
Yes, bail bond. Satisfaction of?
Government servant, my lord.
No. Satisfaction of which court?
The learned
Special court.
Special court.
NDPS.
Satisfaction of special court?
NDPS.
NDPS.
Aizol.
Aizol. And those conditions, 1, 2, 4, 5, that NDPS conditions. Disposed of.
I bow down.
At the end, you write, it is needless to clarify that any observation made in this order is tentative and for the purpose of disposal of this bail application only and shall not be used for any other purpose in any other proceedings whatsoever.
Deeply obliged.
Disposed of.
Item 10.
Disposed of. Huh? Yes, Ms. Fanai, 22C.
Yes, my lord.
22C.
Yes, my lord. But however, there are a lot of irregularities.
All right.
And illegality.
This is the first time it has come.
Yes, my lord. This is the first time.
Miss Linda, you are ready? Yes.
My lord, our main points I'll say in brief first. There's violation of section 42, and however in the trial court at the time of hearing, at the time of opening of case, it was argued by the PP that it is covered by section 43. However, my lord, that I will come to that. It's not covered by section because it's a private vehicle in a public place.
Private vehicle?
Yes, private vehicle in a public place, and which is not covered under section 43.
Therefore not under.
And also it's not a chance recovery. There was prior information and then it was not, it was waiting, which is evident from the deposition of the seizing officer as well, which we have annexed. I will come into that again. And there is gross violation of section 52A regarding the inventory before the magistrate. Yes. And the seizure witness in their deposition have stated that they did not put their signature on the sealed and resealed and packet of the seized article at the time of seizure.
Authority of the Apex Court which says that these are mandatory. There is one decision on.
Yes, my lord. 52. It has to be attested.
No, you are carrying that authority or not?
Yes, my lord. I'm carrying some, but I don't know specifically. It was. Yes, 52. There are some, quite a few, and also, my lord. There is violation of section 42 as well. Prior information was there. There are 3 seizures. There are 5 accused. All of them, all the others are discharged. And we are the only one facing trial. It was discharged by the special judge on the grounds that there are not enough evidence. However, we are facing trial because it was recovered from our truck. And I am a professional driver.
You are the driver?
Yes, the driver owner.
You are the owner also?
Yes, I am the owner also, which the truck also, so which I had.
Contraband articles have been
recovered.
Have been recovered from your possession?
Yes, my lord. One, however, they are seizure.
So you are only building a case that there has been a violation of the mandatory prescription of the procedures. Which
yes,
are
my lord.
required to be followed.
Yes, my lord.
Namely section 42 and 52A. That's your case?
Yes, my lord. And section 46 of the CRPC as well, as per the rulings of DK Basu versus State of Bengal, the intimation was not given. And
intimation of what?
Intimation to the family. There are some guidelines which have been observed in that ruling with regard to the arrest of the accused and the detention of the accused. And then those guidelines that it has to be like signed by one of the relatives, which is mandatory.
Mandatory?
Yes, my lord, which were not followed. And also the
mandatory or directory?
It is a guideline, so
That's why I'm asking. These are procedures. Mandatory or directory? Mandatory, or if it's directory, even non-compliance will not make it fatal.
However-
Because you see, C is involved, 22C, right? Offenses.
yes, my lord.
So what this court has to see, because the court is bound by 37, correct? So the court will have to see that whether prima facie a guilt is made out or not. Now suppose
Yes.
there has been violation of some procedures which are mandatory to be followed, then of course no conviction can be made out.
Yes.
Because at the end of the day it will be fatal. In that situation, yes, you are right, bail can be granted.
Yes, my
But
lord.
suppose for non-following of certain procedures which are not mandatory but directory, then the conviction will not be affected. In that situation, since the contraband articles have been recovered from your possession, prima facie a case is made out. Correct?
Yes, that also, my lord. That again is also in. There are two seizures, and then in the next seizure, it was seized from the office of the excise and narcotics. It was like written in the seizure memo itself. That is also not seized from my possession, allegedly from the.
Let us see the paper.
Also, my lord, there.
Yes.
Yes, my lord. If I may start with violation of section 42.
Page.
This page.
Where is the complaint? You are Mr.
Malsom Enga.
Accused number 1 at serial number 1, right?
Yes, my lord.
Page 24 is the complaint.
Let me see here, there is my lord. 24. My lord,
Yes.
if I may take you to page 29 of the application.
20. Just come to 24 one.
24.
The facts is here. Just let us see the brief
Yes, my
history.
lord.
You can read.
The history of the case in brief is that on 23rd November 2023 at around 5 p.m., Asylum Nunfela received information from his source stating that Joinul Haq and his friends staying at Punjong were trying to receive contraband articles by means of vehicle Bolero pickup so-and-so from one vehicle Bharat Benz so-and-so driven by Malsom Enga of Qatar. S.I. Nunfela recorded and report in writing and informed the officer in charge, ANS. The above cited officer formed a team to locate the suspected person. The duty team intercepted the suspected Joinul Haq and his friend Majibur Rahman with Bolero pickup bearing registration number so-and-so and at Durtlang Road, Aizawl, and they detained them. Asylum Nunfela interrogated both the accused persons. From the light of investigation, the duty team, along with the said Joinul Haq and Majibur Rahman, proceeded to Falkland Way, Aizawl, to intercept the seized vehicle, Bharat Benz truck, driven by accused Malsom Enga. The duty team saw the seized vehicle and the accused Malsom Enga and Malsom Kima on the World Bank Road near Hola Park, Falkland Way, Aizawl. Asylum Nunfela detained there.
All right, I've read this. Now you want me to go to 29?
Yes, my lord.
Yes.
This is
Information.
This is the only information and which is not sufficient as per the section 42 of the NDPS Act, my lord. On date 23/11 at around 5 p.m., I received information from my informant who stated that one Joinul Haq and his friend his friend was staying at Punjong at Bolero pickup AS 119906. They were trying to receive contraband articles from Bharat Benz MZ01 7Z784 driven by Malsom Enga of Qatar. That, my lord, here it is stated that even though it seems that the information was recorded later on after the arrest. Because from the evidence and from the facts of the case, if we go through the charge sheet, then it is evident that the evident that the information about Malsom Enga was given after the.
From where are you saying all this?
No, but I'll take you to that.
No, but where is it evident that these all came later? It was recorded.
In the.
How? From where are you inferring all this?
From the statement of the SO, seizing officer, at page.
What is the position? This is trial has started.
Yes, trial has started.
How many witnesses examined?
There are 2 or 3 are still remaining, my lord.
Miss Linda, do you have the position?
No, my lord, I don't have.
I think you find that
The
out.
case IO,
Yes, madam, can do that.
the case IO is still left, and the GMFC.
No, let the public prosecutor find out the status of the trial.
Yes, my lord. And there are 2 seizures. And the second seizure was apparently, it was alleged.
And you see, Miss Linda, you must, you've already heard the submissions. The primary submissions are that section 42 and 52A has been violated. So you look into that.
Yes, madam.
And also whether these are mandatory or directory.
Also, my lord, the rules are not, the NDPS rules of 2022 are not followed. The Form 1 is also not followed, which is accepted by the seizing
Whether
officer.
those are mandatory or not, you have to show.
Yes, my lord.
You see, I've made it very clear. If you want to make out a case that rules not followed, you have to show that those rules are mandatory.
Yes, my lord.
So when do you want it? Friday, Monday?
Your lordship will be here on Monday.
But this can be
My
taken
lord,
up by
tomorrow-
anyone.
Friday?
All right, Friday. But Ms. Linda, just find out what is the status of the trial, because that could be of some, but you have to, this court cannot ignore that this is under 22C.
Yes. Also, my lord, the test memo itself was not there in the charge sheet, which is a very important
Very
thing.
well.
And I have some case laws in our favor, a lot of them, my lord.
No, which are the ones which says that these 2 sections are mandatory? Please give me the citation. You have a photocopy?
Yes, my lord, I have
You,
a photocopy.
Miss Fenai, kindly do one thing. You ask your junior to just hand over the compilations of the case laws and just to write on top. Suppose it is on section 42, paragraph 52A, paragraph.
Yes,
To
my
that
lord.
extent, and give it to my court master, please.
Yes, my lord.
Relist on Friday for further
Obliged.
consideration. I am not recording that you need to. Shall I record that?
No, madam, I'll find it out.
All right, I can just record that. Miss Linda, so and so PP shall apprise this court on the next date of listing as regards the status of the trial.
For admission. Item number 4.
This one. Yes.
Yes, Lordship, this is regarding the statutory deposit.
Have you
I have
made
checked
it?
from the registry, Lordship, we have submitted on 29/5/2023.
All right. Heard Mr. Johnny L. So-and-so, Learned Counsel for the appellant. Stop. Also heard Mr.
Lalchan Lena Kempe.
So-and-so for respondent number 1 to 4.
1 to 4.
1 to 5.
For respondent numbers 1 to 4. Stop. This is an appeal under Section 173 of Motor Vehicles Act 1988 for setting aside the impugned judgment and award dated 7/12/22 passed by the learned presiding officer MACT Aizol in MAC case number 7 of 2017. Statutory deposits as required under Section 173 of the said Act has already been deposited before the registry of this bench on
29/5/2023.
29/5/2023.
2023.
Stop.
Yes.
Admit, issue notice, returnable 4 weeks. As Mr. So-and-so Learned Counsel accepts notice on behalf of respondent numbers
1 to 4.
1 to 4, comma, no formal notice extra copies within a period of 3 days from today.
Yes.
Registered post AD in respect of the other respondents. You are in this matter, Mr. Lal Ramenga? You are very eagerly standing up. I thought you are also appearing. Issue notice, notice by registered post AD, and then case records will be required. Case
Yes, sir, that's a
records
case
from
record.
MACT, ISOL be called for, list after 4 weeks on a date to be fixed by the registry.
Lordship, I seek your indulgence.
Item number 5.
Yes, you want to say something?
Lordship, part 2, item number 5. The respondent comes.
One sec. Part 1 is over.
Not over.
Why are you
I cannot. I didn't know that.
intervening in the middle? Part 2 is yet to be called. Wait for your turn.
I'm very sorry, my lord.
Wait. Yes. Which is this? 5 off? 5 is not done. No, 5 is done, I think.
This item was passed over for the time being, my lord. The
Item
other
number
side's-
5.
Yes, the other side's counsel was, at that time he was
Yes.
coming towards the court.
Oh, this is that second appeal.
Yes.
Where initially I thought you were seeking adjournment and then pass over for the time being. Yes. What is the substantial question of law involved? It's an RSA.
Yes, sir. Your Honor.
Where are the substantial question of law formulated? Mr. Lal Ramenga, you are for the respondents?
Yes, your lordship, I'm for the sole respondent.
Very well. We will hear you at the time of hearing.
Yes.
You can sit right now.
Yes, my lord.
Yes.
Your Honor, may I please take you to page number 31 of the Memorandum of Appeal?
30?
131.
Yes.
The first substantial question of law proposed is whether the Land Lower Appellate Court is right in reversing the judgment and order dated 24/6/2022, whereby the will dated 12/1/2018 was probated without any proof of soundness of mind of the testator and without clarification of suspicious circumstances surrounding the will dated 12/1/2018. May I go to number 2? Whether the Land Lower Appellate Court was right in determining that no suspicious circumstances are present surrounding the will dated 12/1/2028. And proposed number 3, whether the Land Lower Appellate Court was right in taking the presence of handwritten will as a conclusive proof of soundness of mind of the testator, though the same was not produced before the court during the course of trial.
Mind was challenged. You are the person who challenged the will.
Your Honor, yes.
Huh?
Yes.
You had sought probate, Mr. Lal Ramenga?
Yes, my lord.
Your
I
client
was-
sought for the probate.
I was the petitioner in the probate case.
You were the
I applied for probate of my
And-
father's will.
And the respondent had
File written objection.
had disputed the soundness of the
Yes, my lord.
maker,
Yes.
but that was not gone into.
And it was dismissed by, the will was not probated, it was dismissed by the learned trial court. And I preferred the appeal, RFA, which was granted to me, madam. And the will was also probated by the
So
appellate court.
this is the against the reverse
Exactly, madam.
order.
Yes.
Where the second appeal is filed.
Yes, madam.
And where is the finding of the appellate court as regards the soundness of mind?
Page number.
Why was the will not probated at the first instance?
Your Honor, the trial court had passed judgment by stating that several doubts arises as to the genuineness of the validity of the will.
So the trial court had doubted the genuinity of the will.
Yes.
Now, why was this reversed by the appellate court? Where is the finding? Decision
The findings
and
here,
finding?
Your Honor, that the proposed
Page,
substantial
page.
question of law number 3.
Page.
Okay, page number 9.
Page number 9.
The judgment of the first appellate court.
All right. Yes. Yes. You may read.
The existence of a handwritten will by the testator is also brought out by the respondents in the cross-examination of the appellant applicant, which clearly denotes beyond reasonable doubt that the testator, Puvanal Vunalait, was sound and conscious at the time of executing his will, for an unsound person would not have a handwritten will. And this court opines the availability of the handwritten will by the testator is not an issue, as its existence is pointed out by the respondent, and such is a clear evidence of the soundness of the testator. And that was regarding soundness of the mind of the testator.
How can the existence of the handwritten will decide the issue of the soundness?
Your Honor, the same was never produced before the court. It was never included in the pleadings of probator also.
All right, let us see the questions again. I'm admitting it.
My lord, if
Where is your right to object at this stage?
my lord,
You have all the right to show at the time of hearing that the
That is
issues
true.
framed by this court does not involve
substantial
question of law.
my
You do not have any right now. I have seen it.
I'll confine myself only with regard to the proposed substantial question of my
How
lord.
can you,
This is
Mr.
with-
Lalramanga,
Yes, my
show
lord.
me that you have a right to be heard? First, show me that you have a right to be heard.
with regard
That's
to
why
sub-
I told you in the beginning
Yes.
that you may sit and we will hear, this court will hear you at the time of hearing.
my lord.
You have no right to be heard. I'm sorry. Yes, OP. Heard Mr.
Samuel
Samuel Lalram Ruata, Learned Counsel, appearing for the appellant. Stop. Also heard Mr. B. Lalram Myanga, Learned Counsel, for the sole respondent. Stop. This is a second appeal. Under section 100, read with order 42, CPC 1908, preferred against the judgment and order and decree dated 21/7/2023, passed by the learned Additional District Judge 1 Aizol in RFA number 31 of 2022, arising out of probate case number 4 of 2018. Stop. The appeal is admitted for the following substantial question of law. 1, page 31. I think 1 and 2 is sufficient.
Yeah.
More or less the same. All
More or
three.
less, yes. 1 and 2 will be sufficient.
Yeah, will be sufficient.
1 and 2. Since Mr. B. Lalramenga enters appearance on behalf of
Sole respondent.
comma, no formal notice is required. Extra copies, you need extra copies?
No, your lordship. One is suffice.
Case records have been called.
Not yet, your lordship.
Case records be called from the court of
District Judge.
Civil
addition-
Judge 5.
Yes, my lord.
Huh?
Civil Judge 5.
Sorry, additional district judge 1, Aizol, Judicial District, Aizol. Correct? Am I correct?
Yes, as well as your lordship from the Civil Judge 5.
And also from Civil Judge 5, Aizol, Judicial District, Aizol.
Yes.
List after 4 weeks on a date to be fixed by the registry.
My lord, Civil Judge maybe Junior Division. Now it is
Please,
designated as Junior.
give the correct designation, otherwise there will be difficulty. Mr. Samuel, Mr. Lalremanga is doing your work.
Yes.
Case records from which courts?
From Civil Judge 5, Junior Division.
Did you get it, OP? There may be some confusion. Can you just write it and give it
Yes,
to the
my
court
lord. I will
master,
do
please?
that, your lordship.
Mr. Lalramanga?
My lord.
Subsection 5 of section 100.
Yes.
Only for academic reasons.
Yes.
The appeal shall be heard on the question so formulated, and the respondent shall, at
Yes.
the hearing of the appeal, be allowed to argue that the case does not involve such question.
This is true. I immediately realized this section, Your Lordship.
All right. Next.
Thanks for that.
Please give that note. Give that note.
Yes. I'll just do it right away.
Yes. Part 1 is over. Yes. Call for part 2.
Lordship, this part 2, item number 5.
Yes.
I was informed by the learned respondent
This
counsel.
I think they wanted to do tomorrow.
Yes, but my lord, I have fixed item tomorrow. So if you allow me, I make my submission today. Because
No,
on
I
Friday,
think it will be difficult to take
Friday
it up
I
in
have
piecemeal.
Fridays I have a personal difficulty, so maybe my lord.
Who
we can
had
take
mentioned,
upon.
who had mentioned in the morning for the respondent?
Yes,
They
respondent.
did not take your consent.
They had informed me, but my lord, tomorrow I had another fixed item.
That I
So-
understand, but if
yes.
they have informed
So-
you, then why did you initially consented? Because now they are not there.
Today they have my doctor had informed me that I have an appointment on Friday.
All right, but tomorrow in their presence, I will fix this matter in the next week.
Okay, my lord.
All right. You remind me tomorrow. You may not be there. I've taken note of it.
Okay, thank you.
Next week we'll fix it.
Okay, thank you, my lord.
Part 2, item number 6.
Remind me, huh? 6. What is the second appeal?
Your Worship, we have a joint request, Your Worship. If this matter can be adjourned for 2 weeks.
All right.
My lord, actually, I have gone through the record, the order sheets, as just like the previous matters. This is second appeal, and so far of the order sheets concerned, substantial question of law have not been framed.
Not been framed?
Yes.
Substantial questions have not yet been framed. And
Yes.
how is this matter posted for hearing?
Yes. Actually, it was admitted, but I've checked.
Let us see. Let us see.
I might.
2020 matter.
Yes.
This is a 2020 matter.
Yes. But at the times of Justice Nelson admitted, and it was that time.
One second. He may be right. And when was it admitted?
My
I
lord,
see notice was issued. Admission order? Or which
it
is
is.
the,
I have seen it just now. It.
you saw the
Yes,
there-
at the
there-
very first. I think in the first day.
No, the first day is a notice. 1/12/2020. Having regard, let the appeal be admitted. Yes. How come this appeal has been admitted and no question have been framed?
Actually, my lord, this is very peculiar case. This type of matters is from Autonomous District Council. As the practice we have.
Be then as it may, but it's a second appeal. How can the second
No,
appeal
actually,
be
the
taken up
practice-
for hearing without substantial question
The
of law?
practice we have is that in this Pachunga versus Zokumi, 1983, volume 2, GLR 482, this kind of appeal normally is considered as first appeal. And in some other matters also,
No, you are citing some authority.
I have in my page number 9 also.
Page number?
Page number 9. Para number 7 of my memo of appeal.
Yes. This instant appeal may be considered as first appeal. What is, where
Yes,
is this?
this is
petition?
Appeal District Council Court.
Mr. Malhotra?
Lordship, if this matter can come up tomorrow, there's a rules, there are Guwahati High Court rules, which says that the district council court orders will be treated as first appeals.
Do you have it? Because
Yes, this-
otherwise,
I have the judgment also here. I have highlighted also.
no, but you look into it,
Yes.
Mr. Malhotra, because we'll have it when? Tomorrow?
Tomorrow,
Yes, tomorrow, my lord.
Monday?
Monday.
My lord, actually, I'm leaving on Friday. Actually, as
Well, Ms. Julie
After
can be
you're
there,
back.
just that.
I'll be back after 2 weeks.
I'm posted after 2 weeks then.
That's fine also, my lord.
As prayed, I'm not recording this, I'm saying as prayed for, list this matter after,
Well, can I have fixed date?
yeah, list this matter on such and such date. Please give a fixed date.
Sure.
Give a date.
September 23.
So and so. To enable the parties to apprise the court as regards the maintainability of this second appeal without as regards the hearing of the second appeal without formulating substantial question of law.
Item number 8.
Then at least it will be clear.
Yes, Lordship.
My lord, some other matters come from District Council Court.
Very
It
well.
Always.
Matters may kindly be adjourned, Your Worship. The
When-
councils for the result after 2 weeks.
Respondents are not here.
Yes, Lord.
Heard Mr. A.R. Malhotra, learned counsel for the appellant. None appears for the respondent number 4 respondents when the matter is called. As prayed by Mr. Malhotra, list this matter
After a week.
after a week on a date to be fixed by the registry.
Item number 11.
Yes, are you appearing? Are you appearing in this matter?
My lord,
regarding
regarding
the-
that first appeal, the rules say,
Oh. It can be treated as a first appeal. Which one? District Council Court.
yes,
Your page 259, bottom, the note number 1.
even the judgment also which I reflected is also there in that rules.
All right, I will just modify that order.
Yes, all right.
Yes.
Item number 11.
None appears when called. List this matter after 2 weeks on a date to be fixed by the registry.
Item number 13.
Done?